All right, first up, the difference between sealing and expungement. The main difference here is access. When you seal your records, it limits the access to who can see them, as opposed to when you expunge them, virtually they're gone. They're destroyed by our office, by the courts, by probation. When you seal your record, you can say that you have no record first in certain instances. Those instances could be when you're applying on a job application or for housing, as well as certain licenses. However, those sealed records can be used at a time of sentencing if you're later found guilty of another crime in the future. For an expungement, they're destroyed. You can say no record. You can say no record for anything virtually, and it also allows you to get a license to carry a firearm. This is kind of a brief, kind of just an example of how it's easy to explain the difference. If you have a stained spill on a couch, you can put a cover over it, and that's essentially you sealing your records. Some people can lift that cover and see the sealed records. If you are expunging your records, it's essentially like you replace the cushion altogether. It no longer exists. No one can see that spill. All right, so first I'll get into sealing of the records and the process. Prior to sealing your records, it's very important to get multiple copies of your complaint and your docket, because once it's sealed, you will not be able to unseal them and get those. Additionally, even if you have a defense attorney, they will not be able to as well. And if you're not a citizen of the US, please speak with an immigration lawyer prior to sealing any records. So there's two ways to seal a record. You can seal it by mail with a waiting period, which I'll talk about in a minute, through the Commissioner of Probation, which is an office in Boston, or you can do it by a judge in court with no waiting period. But this only applies to a select few of cases. First, you can, let me just move, see if I can move this. Sorry. All right, sealing through the mail with convictions only. If you have a felony conviction, you can petition to seal that felony conviction after 7 years of a waiting period. It's going to be from the date you were either found guilty of that conviction or when you were released from incarceration, if you were incarcerated, whichever period is later. If it's a misdemeanor, you can petition after the 3-year waiting period. And again, it's going to be whichever period is later. It's either going to be when you're found guilty or released from incarceration. Just a caveat there, if the offense was originally a felony, if it was I think we're back going again. Okay. You can, even though your case may have been dismissed immediately or no cross by our office immediately, you still have to have the waiting period of 7 for a felony or 3 years for a misdemeanor. And this is only through, again, this is through mailing, sealing through mail. However, these non-convictions, the dismissals and the no process, and additionally the continuations without a finding, can be done immediately in court through another process, which I'll discuss. Oh, there we go, got it. Okay, again, the waiting period, this just kind of lays it out a little bit more. 7 years for a felony, 3 years for a misdemeanor. And it's either when you're found guilty at that time period. For example, you could have been on probation, you're found guilty that day. It's from that date you're found guilty. Or if you were sentenced to a period of incarceration, whichever period is later is when your waiting period clock will begin. Here I put together a couple examples of sealing convictions to kind of outline the process. I'm going to read them out. I think it kind of puts a little bit of emphasis on it. Jacob is found guilty of a felony in 2013 and sentenced to probation. In 2020, he can seal that record. This is because it's a felony conviction. He's placed on probation. So the day that the felony is considered a guilty conviction, he has 7 years from that period of time. So in 2020, he'll be able to seal that felony. The next one, Megan is found guilty of a felony in 2013 and sentenced to serve 2 years and is released in 2015. This is when he is sentenced to incarceration for a period of 2 years. So in 2022, she can then seal that record. This is because it's a felony and she has to wait 7 years from the period that she is then released. Okay. So next one, Joe is found guilty of a misdemeanor in 2018 and sentenced to serve 2 years and released in 2020. In 2021, he commits a felony and is sentenced to serve 3 years. He's released in 2024. He cannot seal either conviction until 2031. This is because, I'm not sure if the slide said it, I had missed a slide, but this is because your waiting time period clock will reset again if you receive another conviction. Exactly what happened to Joe here. He then has to wait until the end time period of that very last conviction, whether it's 3 years or the 7 year time period, to seal either his earlier one or his later one. So the procedure to seal by mail, once you make sure you met that time period, you can fill out a petition. We have petitions here today. We can also make sure that there are petitions. Most of them are available on the Commissioner of Probation website as well. And you can mail the form directly to them. There are certain convictions that do have a longer waiting period. These are the harassment prevention orders and abuse prevention orders. They are considered misdemeanors. However, they do have a 7 year waiting period, like a felony would have. Additionally, any sex offenses are also going to carry a 15 year waiting period, and it's going to be from the last date of the event in your case, whether it's the end of your probation, supervision, or release from incarceration. I'll get a little further into the sex offenses. However, you cannot seal anything if you are currently registered as a sex offender at that time. This goes into a little bit more detail, but SORB has 3 levels. If you're considered a level 1 offender and you do not currently have to register, then you have a 15 year waiting period to seal that conviction. However, if you are a level 2 or a level 3, then you can never seal that sex offense conviction. Having said that, if you have other convictions on your record other than that sex offense, you can seal those. That is only for the sex offense. There are certain offenses in general that can never be sealed. Some state ethics violations, some firearms. As stated before, the sex offenses. Those ones cannot be sealed, but if you have any other convictions, that meet the requirements and the waiting period, those ones are eligible to be sealed. This is kind of just a checklist. Again, you're going to need your waiting period, which is 3 years for misdemeanors, and your 7 years for felonies. And then you can have no other convictions occur during that waiting period. If they have, then your waiting period is reset and you begin again. Here's the second way to seal any kind of, these will be your non-convictions that can be sealed in court. They do not have to be done by mail. There's 3 types of cases that can be sealed in court. You were found not guilty of a crime. Your case was either dismissed or a nolle pros was filed. And this also includes a continuance without a finding. This is when there is no waiting period. If a not guilty was entered on a case of yours, perhaps after a jury trial, you can immediately seal that in court. Hypothetically, the next day you could file a petition. Again, some examples of sealing dismissals. Jacob is found not guilty of a felony in 2013. He can seal in court by a judge immediately, or he can wait the 7-year period, which would be done by mail. Even though he gets a not guilty in court, if he wants to seal it by mail, he still has to wait for his 7-year period. The procedures for sealing the cases in court, there's no waiting period. As discussed, it can be immediately done. The process is free. The petitions, you can find the petitions, we have them here today, as well as in the courthouse. And you have to file them in the courthouse where the case was handled. You may also have, depending upon what the district attorney's office decides to do, there may be 1 or 2 hearings to determine whether you have the ability to seal that. There are helpful documents that you can bring with you if you do want to seal in court with a judge. The court has to give a notice 7 days prior to a sealing petition. That gives the district attorney's office time to look into it, as well as anybody else that may want to object to it. And the standard for this is good cause. You have to show that you have some kind of foreseeable either future or current disadvantage due to the conviction or non-conviction perhaps that is on your record. Any helpful information that could be included is an affidavit from you individually indicating how this is hurting your future, any letters of support from professionals, as well as any kinds of certificates that you may have received. Who has access to your sealed records? This goes back to, although you may seal a record, certain individuals still have access to that. This is the Department of Early Education and Care. This also includes any subcontractors who are subcontracted out to look into, like, perhaps daycare workers. They still will be able to see that sealed record. DCF, if you wish to adopt or foster a child, DCF and Department of Youth Services still will have that ability to see the sealed record as well. Any criminal justice agency, including the courts, probation, police, the DA's office, they still have access to sealed records. However, you yourself may not have access to that record anymore. You will not, and neither will a defense attorney if you need them in the future. Okay, so I will go on to the process of expungement next. As I stated a little bit ago, expungement means essentially that they're destroyed. The DA's office no longer has them, the courts no longer have them, they are gone. It's important to not expunge any records prior to speaking with an attorney if you're not a citizen of the US, as well as if you have a conviction that is a result of some kind of drug lab issue that has happened prior in the state of Mass, then you may want to speak to an attorney prior to expunging those records as well. And you do, as well as for sealing and expunging, you always want to get copies of your docket and any other records that you may need, because once they're sealed and expunged, you won't have access to them. There's two types of expungements. There's a time-based expungement and a reason-based expungement. Both are a little different process that I'll get into. So for your time-based expungement, your offense had to have occurred prior to your 21st birthday. And recently, the law recently changed on this to make it easier for individuals to expunge their record. Now you cannot have more than 2 incidences on your record. However, you can have 4 or 5 charges on your record, but there can only be 2 dates of incidences. For example, you could have been charged with disorderly conduct and assault and battery that existed January of 2020. That would be considered 1 incident. And then you can have 1 more incident that may have occurred 3 charges. That would be your 2nd incident. So you can theoretically expunge 5 potential offenses if it's only as to 2 incidences. Again, there will be a waiting period. The waiting period for a felony offense is 7 years and 3 years for a misdemeanor. And it's from the time you completed that sentence. There is a minor note there. If you are under current criminal investigation for any other reason, you are not eligible to expunge. There are a list of certain offenses that can never be expunged for any reason. Most of them are serious felony convictions against a person, OUIs, firearm offenses, restraining order violations, sex offenses. Even if these were dismissals on the docket, they still cannot be expunged. Having said that, you still may qualify for sealing of those records. These are a prime example of particularly what our office has been getting for expungements requests: disorderly conduct, trespassing, shoplifting, drug possession, larceny, misdemeanor assault and battery. Again, has to be prior. Again, expungement is difficult because it has to be prior to your 21st birthday. There's no getting around that. If it was after your 21st birthday, then we can still look to see if it's possible to seal. The procedure for time-based expungement, again, there's a petition that you file with the Commissioner of Probation directly. This is again in Boston. At that time, they will then notify the DA's office if you qualify. Our office then has the ability to either object, or what we've been doing in the past, if we agree, is we send a letter that we do agree and we believe this person should be expunged. If we do object for whatever reason, a hearing can be held, and ultimately the court will have the discretion. Okay, the second reason or way to expunge your record is a reason-based expungement. There are a certain number of instances, and it's very strict, that you will be able to expunge after your 21st birthday. There is no waiting period for this. It's not limited to the to 2 incidences on your record. However, there are only 6 ways that you'll be able to do this and prove this. The offense is no longer a crime. For example, you may have prior to on your record possession of marijuana, which is no longer a crime with 2 ounces of less. That one will be able to be expunged. You're able to prove that there was either a false identification or unauthorized use of your identity. There was a demonstrable error by law enforcement. This could be a number of things, but particularly could be false allegations or lying on the part of the police department. And then errors by witnesses or court employees, or a fraud that was conducted on the court. These are hard to prove, however possible. And for this, again, you will, instead of filing a petition with the Commissioner of Probation in Boston, you'll file it directly with the court that handled the case. At that time, the district attorney will have the ability to request a hearing, and you will need to provide evidence to the court and to the district attorney. The legal standard to this to prove that your record was created as a result of one of these 6 incidences is by clear and convincing evidence. Once you have established this, the court has the discretion to expunge that conviction or entry on your record for what is in the best interest of justice. This is just a brief recap. I briefly discussed the 2 different ways that you can seal, as well as the 2 different ways you can expunge your record. Again, sealing, it just limits the access someone has to your record, whereas expungement means it's ultimately destroyed. No one no longer has access to it. And that's it for my presentation. I'm here to take questions after, but I'm assuming Matt was going to go first. Okay.
There's one question you want to. You want a question, Megan?
Sure.
Is there a waiting period for the reason-based expungement?
There is a yes. Oh no, there is no waiting period.
No waiting.
No waiting period. You just have to demonstrate by the 6 reasons why for the reason base, with no waiting period.
Yes.
That's it. I'm gonna have to share your. Yeah.
I know you're right.
Oh, yeah, there it is.
Yeah, click on this one.
Yeah. This computer is not very. Okay. There you go, Andy. Sure you're muted.
Hi everyone, my name is Annie Maurer. I am one of the staff attorneys at Community Legal Aid in Pittsfield, and I work in the Quarry and Reentry Project. This is a project we've had at Legal Aid for a number of years, but I started in June in the Berkshire office, the first time that we've had a dedicated staff person doing this work in Berkshire County. So I'm going to talk a little bit about what your rights are if you have a criminal record with respect to applying for employment and housing, and just talk a little bit about what, Megan talked a little bit about how when you can say I have no record, even if you do have a record that's sealed. So I'm going to talk a little bit about what your rights are when you go through the process of finding a new job. Okay. A lot of people have heard of the term ban the box in Massachusetts, which essentially was a law that the legislature passed prohibiting employers from asking people about their criminal records at the application stage. And that's really the extent of what ban the box means. It means that you have to get in the door before someone can start asking you about your criminal record. So that's a question that they're not allowed to ask you at the application stage. You should be able to get screened for basic qualifications, and then they're going to run your criminal record, or what we call the quarry in Massachusetts, at a later stage.
It's still up. I don't think it's screen sharing.
disconnection. I think it's the HDMI cord if it gets touched.
Yeah.
It's awfully sensitive.
There it is.
Does it look okay?
Okay, so if you get past the initial application phase and an employer is asking you for permission to run your criminal record, then, and you have a sealed or an expunged record, you can answer that you have no criminal record. The law explicitly allows you to say that even though you may have a sealed record, you're allowed to say that you have no record. Every employer has to have a CORI policy, and the CORI policy is supposed to outline for the employer what procedures they're going to follow when they're trying to hire someone who has a criminal record. It has to be in writing, and you know, if you ever are confronted with a situation where you're getting rejected from a job and you believe that the employer has not followed either state law or their own CORI policy, you can ask to see that. And of course, you might want to talk to me or someone like me before you go through with doing something like that, so we can talk about the rules. Employers are not allowed to ask you to supply your own CORI. It used to be that often employers would ask you to go run your own record or have a private background check company run your record, and then you would have to supply it. That's not allowed. If they want to run your record, they have to get your permission, and then you are not allowed to be asked to supply it yourself. Now, if any employer is going to make a decision not to hire you based on your CORI or your criminal record, then they have to tell you that's why they're not hiring you and why. Like, what about your record is giving them pause? So it could be that there's only one conviction that's a problem for them. So maybe you're applying to be you know, behind the counter at a cash register and you have a theft offense on your record. Well, if that's their concern, they have to tell you what it is, so that ultimately you have a chance to respond and answer their concerns. They also have to give you a copy of the criminal background check that they use. So if it's the official CORI through the DeCegis website, they have to give that to you. Or if they use a private background check company, they have to give you what they use, so that you have an opportunity to dispute anything that's inaccurate or put it in context. Because this is often an opportunity for folks who have a criminal record to explain why that incident in their life was either an isolated event or part of a greater context, and why it's not relevant to the job that you're seeking out. And so you have a right to dispute that and to have a conversation with the employer about what your criminal background says.
So
Yeah, it might just.
No, I'm very sorry.
A couple more rules that it's good to know about if you're going into an interview when you have a criminal record. Employers are not allowed to ask you about anything that has been sealed or expunged. You know, maybe they Googled your name and they found that you were arrested 10 years ago, but that case is now sealed or expunged. Employers are not allowed to ask you about that. Many employers do not know that. But it's good for you to know that going into an interview, so that you're ready with what the rules are, and that you can prepare yourself for how you're going to respond if they ask you a question they're allowed to ask you, or if they ask you a question that they're not allowed to ask you. They're not allowed to ask you about anything that has been dismissed. So a continuation without a finding, or a non-conviction, or a juvenile record, they're not allowed to ask you. They're also not allowed to ask you about a misdemeanor that's 3 or more years old from either the date of your conviction or the date of your release from incarceration. And if you don't disclose something that's, so let's say you have a 5-year-old misdemeanor that's not sealed, they're not allowed to ask you about it. And if you don't disclose it and they find out about it, they're not allowed to hold that against you. Again, this is a rule that I think a lot of, especially small employers, are not even aware of. Just briefly, if you're applying for public or subsidized housing, the rules are very similar. So if you're going for a Section 8 voucher, or you're going for an actual project-based voucher, or direct public housing, you're going to run through a similar series of rules with those housing authorities. Again, Corey is the last step. So they have to vet you for income qualification, any age restrictions on that housing, any other kind of vetting that they're going to do, they have to do that first. And when they know that you're otherwise qualified, that's when they can ask you to sign for permission to run your criminal record. They also must have a Corey policy. I can tell you, with my experience in the Berkshire County housing authorities, by and large, they all have Corey policies. They're following these rules. They cannot ask you to supply your Corey. So just like an employer, they have to run it themselves and they need your permission to do so. And if they're going to take any adverse decision against you, so either not give you a voucher, or if you're living in public housing and your case occurs and they want to evict you because of it, they have to tell you why. What about the Corey gives them concern, and then you have a right to dispute that because they're going to have to give you a copy of it as well. And when it's a public housing or subsidized housing, and they say, you know what, we're otherwise going to reject you because of this, you have an opportunity to appeal that. And I'll get to this later, but that is something that my office does a lot of, is represent people in those appeals. My basic message to people who have a criminal record when they're going out for a new job or for a housing interview is that you need to have a plan, because this stuff is going to come up, and you want to be prepared for how you're going to handle it. And it may be that you, if you do your research, you find out, oh, this isn't going to come up because I've sealed it, or this employer doesn't have access to the level that they need. So go into the process with a plan. The first thing you want to do is you want to know what's on your Corey. If you don't know what's on your Corey, then you can't possibly prepare. And I have so many clients who aren't exactly sure of which conviction was finally entered. You know, it could be that you were charged with 3 and you only pled to 1. So make sure you know what's there. There are also lots of mistakes on Corys, because all the information on the Corey and the criminal record comes from a human being entering it into a computer. So there's lots of mistakes. Check your criminal record. And once you have it, you can compare it to what the prospective employer has access to. I'll talk a little bit about that in a minute. Just some basic interview tips. Just like when you are talking to a judge, when you're talking to an employer, a prospective employer or a prospective housing authority, you want to confront the conviction head on, and you want to own it. You know, you have to acknowledge responsibility and put the conviction in context, because you don't want the prospective employer to think that you're minimizing or denying involvement, because honesty certainly is going to be a quality that most employers are looking for when they're hiring someone. But you have to look at it as an opportunity to tell your story. It's there, they're going to know about it, but you want to try to put it in context. You know, this was one event in my life, and it's not reflective of the kind of employee I'm going to be. You know, it may actually be something that's made you stronger and more resilient than a prospective employee who doesn't have a criminal record. So find a way to put it in context. And I practice for every job interview I've ever had. When you're confronting something like a criminal background, you need to practice, because it's very personal to you. And you might feel like it's not anyone's business, and I happen to agree with you, but if an employer knows about it, they're going to ask you about it. So you want to be ready to confront it. If you think people are running your record without your permission, you can also check through the Department of Probation. You can do what's called a self-audit. We have some forms here tonight. You can also go to the website listed on the PowerPoint. It's going to tell you anyone who used the iQuery system to run your record. Some people may be using private background check companies. It's not going to catch that, but it will catch anyone who's using the iQuery system. I'm going to talk a little bit about the levels of access that different employers have, so that you get a sense of, okay, I'm applying for a job at a school. What are they going to be able to see? Because that's different from what a job at a retail operation is going to be able to see. So there's 4 basic levels of Corey access, and standard Corey is the kind that any private company that wants to pay the fee to get Corey access is going to get. So private landlords are going to be able to find this. Retail, food service, licensing agencies, they get standard access. So any unsealed misdemeanor within 5 years of your conviction or release, or any unsealed felony within 10 years of conviction or release. And I highlight unsealed here because I want to emphasize the power of sealing your record. All of these folks, private landlords, retail, food service, real estate agencies, licensing agencies, if you seal your record, they're never going to know about it. And you can answer when you're having your interview that you have no record. That's a huge, powerful advantage you can give yourself. Required 1 access is a little bit more. So public and subsidized housing providers have this, amusement park employers, banks, hospitals, insurance companies, security card companies. Sometimes I don't really understand why some industries get higher access or not, but that's who's going to get required 1 access. They can see all pending charges, including, let's say you are in the period of probation during a continuance without a finding. That's an open case, so that's going to show as pending, and people are going to be able to see that with required 1. And anything that's unsealed all the way back to your 18th birthday. So they get, that could be a long time depending on how old you are. Again, the power of sealing your record. Seal it, they don't see it. Required 2, religious schools. Religious organizations, schools, nursing homes, in-home care are going to be able to see required 2, any unsealed adult convictions, non-convictions, and pending charges. So we're getting to more access here. And required 3 is going to be the most that like non-law enforcement basically is going to be able to see. And it's a special little niche for camps. They also get access to juvenile adjudications. And the reasoning for that is that often camps are hiring juveniles to supervise juveniles. So they're able to have that special access when they're hiring. Here's my contact information. Because if you have any questions in the future, if you're about to go for a job interview, if you're about to apply for subsidized housing, I encourage you to give me a call and I can walk you through, what your potential employer is going to be able to see. I can guide people through getting their Corys so they can look at them themselves, and we can talk about strategies. So I'm here for any of that. And as I mentioned in the beginning, I work in the reentry and Corey project of community legal aid. I'm just going to talk briefly about what we do in our project. We do a lot of housing work. So whenever someone gets denied from public or subsidized housing because of their criminal record, I'm going to represent that person if they qualify for legal aid in their appeal. And we can work together to put the criminal record in context. And I can tell you that we have huge success in this area because a lot of folks who are ready to move into subsidized housing often have really powerful stories about why stabilized housing actually will enable them to live a life without having to reoffend. We also do a lot of sealing and expungement work, all the stuff that Megan Rose was talking about. We do that for folks who qualify for our services. And we also do employment work. So if you do think you're being discriminated against improperly by an employer, we can represent you potentially if there is anything to do. So with employment, it's tricky because there is a lot of permissible discrimination by employers because of Corey, but we will investigate whether or not the employer has followed the Corey rules. Again, with housing, where we represent people in appeals for denials of public housing, Section 8 vouchers, project-based vouchers. In a housing denial appeal, what I'm going to do is I'm going to make sure that the housing provider follow the rules. And then I'm going to analyze the case through the lens of the Americans with Disabilities Act and the Fair Housing Act to see, so for instance, if your criminal charges are related to a substance use disorder, then we can make an argument under the Americans with Disabilities Act that you are entitled under the law to a reasonable accommodation, which means that the housing provider should ignore or put aside your criminal background because it's related to your disability, which is substance use disorder. And that's a very powerful tool that we have under the law to set aside criminal records when we're dealing with public housing. And then if there is no legal hook, legal argument under the Fair Housing Act or the Americans with Disabilities Act, then we're gonna, and also the Violence Against Women Act we use a lot as well. If I don't have a legal hook like that, then I'm just gonna present mitigation to the housing provider, meaning I'm gonna tell the housing provider about you and about your whole history and why this one isolated criminal offense or maybe a series of criminal offenses do not show why you would be such a great tenant, prospective tenant. And so we're going to present that case that way. As I said, we have great outcomes, especially in the housing realm. And the final thing that we do is sealing, which I already explained. So there's my information. If you have any questions, feel free to call me or you can ask now. Thank you.